we'll stay and talk about, answer any questions that you might have going forward.
I have a question. If you're given partial information on an IPRA request, for instance, like if you ask for a year's worth of data of something and they only give you a part of that year, essentially at that point, if you haven't gotten any response from the custodian, is it considered a denial at that point, or do you have to re-request, do another IPRA request for the rest of the year, or that type of thing?
So, if they don't, again, communication is key here. So communication is key. If a public body, like we were talking about earlier, if they have 15 days to produce the records to you or explain to you that your request is broad and burdensome and talk to you with more time. If they've only produced a certain amount of documentation and haven't explained to you any other reason, I would imagine you could deem that request denied and move forward with the remedies available under the Inspection of Public Records. Now, you cannot have a request in perpetuity, though, going into the future. I want all emails sent to Dylan Lang from now until the end of the year. You need to have it because, again, the IPRA allows for inspection of records at the time the request is made. And so that's what you need to keep in mind. But a public body could, if it's reasonable, if you feel it's reasonable, allow inspection of a large amount of records slowly throughout, weeks or months, if you feel like that's reasonable.
If you're, you said that if your request is denied, you can go to court for damages. But if your interest is not in damages or money, but information, is there a way that court then can give you access to the information?
So, again, that's what a court can do. They can issue an injunction to compel that information to come forward. Again, that does cost money, and it would be a pleading, and you would have to go to court.
And it takes time.
And it takes time. But the Attorney General's office, no one else besides a district court, has the power to compel a public agency to release records. So what I would encourage you to do is see what you can get with that public agency. A lot goes a long way with your personal interaction with the records custodian in that particular body.
Does the $100 a day thing not apply anymore? If it was denied, there used to be it was $100 a day for every day that the record wasn't produced. Is that not around anymore? The other thing I have to ask too is, you said that the records custodian is not accountable if the request is denied. Is that right? Did you say that?
I said they're not personally liable for the
Who
decision.
is?
The public, but if a district court finds in your favor that yes, there was a violation of the Inspection of Public Records, any money awarded to the individual would be paid by the public body.
Well, what about that $100 a day thing? Sorry.
$100 a day would start. That's still in the Inspection of Public Records Act, and it would be triggered
It's
by.
never been enforced. That they don't apply that anymore. So I was just wondering if that's why you left it out.
No, actually, the reason that it's left out is because it doesn't apply to the Attorney General's office.
Okay.
That only applies if an individual brings an action. If we bring an action, we don't get $100 a day. Only if an individual brings an action, it is $100 a day from the day that they fail to give the denial letter.
Okay.
We see very often in the agendas, we'll have some boilerplate item like under the closed meeting session, limited personnel matters. That's not reasonably specific, is it?
General statement like limited personnel matters would not be deemed as reasonable specific. No, you would need something additional to give specificity, to give the public information as to what employee they're talking about, because limited personnel only deals with employees, not contractors. So what employee they're talking about, or at least at a minimum the position that they're talking about.
And if they don't do that, what's your next recourse? Work it out with them or call you guys?
We would say call us. We would say, because one of what we're trying to do in this, and obviously you've seen that we do the road shows across the state, we're trying to inform public bodies. I mean, for the most part, a lot of people, when they go into executive session or when they do violate any of these Sunshine Law Acts, it's because they don't know any better. They don't know the specifics or what's required of them. So that is at least the starting goal, is to educate them. However, it would be incumbent upon us is that if they're going to talk into executive session to talk about a personnel matter that they did it improperly, that action could be invalid. So I mean, it leads to other repercussions because hypothetically that could be a state employee that was released improperly or something along those lines. So it's good to actually notify.
How many time extensions can an agency give when they say that? I think every request I've ever made is broad and burdensome every time. How many times, I've gotten some, like the governor's office will give me like 2 or 4 in a row, sometimes longer.
Again, you're not going to like the answer, but it's, you know, they can ask for a reasonable extension of time. There's not going to be a hard and fast rule about how many times they can extend into the future the deadline to produce all records. But if they're working with you, if you deem they're being reasonable, then that's kind of what the IPRA allows.
What we would suggest, I mean, the key of it is reasonableness. So they would base it upon your request. If you feel that every time you do a request and they're saying it's broad and burdensome, try narrowing your request, something that you wouldn't be able to define as broad and burdensome. If they're saying because you're asking for 50 documents, it's going to be broad and burdensome, do 50 separate IPRA requests. Not, of course, all at once, but if you did it separately, then it kind of takes away that reasonableness to say it's excessively broad and burdensome.
And maybe and also maybe ask them why it's broad and burdensome. Ask them to get that right.
Yeah.
I have a question about creating public records and the availability of records in electronic format. I'm engaged in a struggle with a public records custodian that has a record in his hand that he wants me to come to his office to inspect. And I said, why don't you just scan it and email it to me? And he said that he's not required to create a record under the Inspection of Public Records Act. That kind of seems like a stretch. Under what circumstances can we expect a hard copy to be just scanned and emailed as opposed to having to go buy it?
This is a new issue that's recently come up when the law was amended to say that they should respond in the same medium that you have. This is when email, IPRA requests came in, that we should respond back in an email form instead of you waiting for snail mail for a letter to come through. If a public body does have a document in an electronic format, our interpretation from the AG's office is they should be able to email it to you.
But what if they claim they have it only in hard copy? Is scanning it the creation of a public record according to the Act?
The Act would be silent on that, of course, because the Attorney General's office takes a policy of openness and transparency. We would encourage a public body, yes, scan it to us. That's what we do at the Attorney General's office. Even if we do have it in hard form, we will scan it to you and email it to you if that's possible. I don't really view it as creating a public record. However, I would also feel that they could have the ability, because it is in a paper format, to request to charge you for it. That would be a fine line reading of the law. Yes?
I have an OMA question. When a government employee calls for a public grievance hearing, are those open to the public? I mean, open for recording?
Yes, it would be. One of the things that Dylan pointed out is both within the Opens Meeting Act and with the Inspection of Public Records Act is that any exclusions or exceptions are made. That gives a public body the ability to close it, but it's not a direct hardline requirement. If it's the individual, the employee themselves saying that they want an open hearing, yes, it should be held in open hearing. There are a few exceptions that would relate to legal proceedings. If there was information that could come out that they could feel would jeopardize hypothetically minors or something like that,
Right.
They could then ask for that type of closure. But if it's the employee themselves asking for an open hearing, yes, it should be held in open.
Thank you.
Yes.
You mentioned that emails are among the documents that are subject to public disclosure. What about text messages?
So text messages as a whole are, if they would fall within a public record, under the definition of public record, would be subject to disclosure. However, there's a caveat to that. And I know this from personal experience, is that at least with the majority of cellular service providers right now, they only keep text messages for 30 days. So if the individual themselves deleted the text message off of their cell phone, you would only have 30 days to get that record from the cell phone provider, a copy of it. So that's the tough line that we deal with text messages. Yes, they're more than likely going to be a public record if they relate to public business. That's the key, because of course the text message meet you for lunch is not. But if it relates to public business, it would be a public record and should be disclosable subject to IPRA. It's just a fact, hardline fact, that getting that record can sometimes be difficult.
Deleting it would be against the law, at least to be right.
Deleting them could be deletion of a public record, yes, if it's subject to retention. Now, the Public Records Act just revised their rule as it relates to electronic messages, so that's emails and text messages. The revision of the rule says any transitory messages, again, the ones that we're going to that don't give a hard fine line or weren't created pursuant to law, can be deleted, but if it is required to be retained, then they should. Yes.
You guys have been awesome and helpful this year for me, and I appreciate it. But I have one more request. When you take this show on the road, will you stress with these record custodians that you're training and educating that 15 days is not automatic?
Yes.
I filed an IPRA because I have a source that gave me an email. The email is dated, the email is timed. I do a little bit more due diligence, and I like to get the email from the government agent or employee that sent it directly from the agency to confirm that I'm not getting set up with false information or bad email. So I would think that it's pretty particular when you file an IPRA that says, I would like one email from this date at this time from this person. And the 3-day letter says we need 15 days.
We are working on it. That is something that Dylan encounters this every single day with the phone calls he makes. That is something we are definitely advising public bodies to change up because it's been a practice and it's wrong. So yes, we are absolutely trying to teach that and correct it.
And so I do have one other question.
You said one.
Yeah, I thought of it as you were talking. When you were talking about in perpetuity, I mean, obviously get what that means, the spirit of it. But when we file IPRAs, we've already had this experience where they're going to deem it burdensome, they're going to delay it several times, and then you're a few months down the road. My concern has always been that more documents that relate to the IPRA that I filed will have trickled in or come in from the day that I filed it. Is it acceptable, because what I've been doing is saying from this start date to date of full and complete compliance of this IPRA, so that if they do take 3 months to fulfill it, that everything that came in afterward would also be subjected to the IPRA?
The legal answer is no. No, the IPRA states records at the time of the request. So I completely understand the policy behind what you're doing. The law would say no, they would not be required to fulfill anything additional after that request. You'd have to do a new request, unfortunately.
Especially during ongoing development.
Yeah.
All right, thank you.
Yes.
I'm sorry.
Go ahead.
Okay, thank you. If a communication that falls under the domain of public record is encrypted, do people who are communicating with each other have to provide an encryption key or a password to decrypt it?
Be a little more specific.
Okay.
So like a document, like a locked document, or?
Yeah, or like an email or communication of any sort, like a message or email was encrypted. Would the person who sends that or the person receiving it have to provide a key to decrypt it?
So the policy behind the IPRA is to give the most information possible, and that's why it was actually revised to include the metadata. So technically, any information that would be related, an email message, that would be the metadata that would say, from what IP it was sent, or specific senders' email addresses that could be locked. That information should be provided to you. However, there's that one provision that Dylan went over that relates to databases, is that if they feel that there's a confidentiality matter or something that could be detrimental to the public business, they wouldn't have to necessarily give you the key, they would have to give you the access to the document so they could print it out so you have the document, but not necessarily give you an electronic data key that would be locked.
Okay.
So whatever would be in the policy of giving you the most information possible without compromising any confidentiality or public policy.
Okay, so they could give you the file or communication decrypted, but they wouldn't give you the key.
Correct.
Okay.
Yes, yes, ma'am.
I filed an IPRA with the Independent Review Office, and because they have private emails, apparently it goes through this other server, and that's how they retrieve the emails. So when my record was ready, I specifically said that I wanted it on a disk because it's an electronic file. But instead, the stack was pretty big. And would they, in that case, be able to charge me the price of a disk versus going the extra step in scanning them and then providing the disk?
Yes, ma'am. Yes, they can, and they actually should. That's a policy we're strongly encouraging at the AG's office. Whenever there's a large amount of documents or electronic documents, we are strongly encouraging records custodians to either charge the cost of a disk or the cost of a thumb drive, or an individual can bring in the thumb drive. Yes, especially with the changes of electronic documents and how much more accessible and easy they are, we are definitely encouraging that, the actual cost of transmission.
Okay, but because they're private emails, the records custodian or the city clerk said that she had to download them and print them, and then by asking for a disk, she would then have to scan them in order to put them on a disk. And so my question was, would I be able to get the stack of papers for the same price of the disk, since it would essentially be the same thing? If in fact that is true, what I was told.
Not in accordance with the law. The law would say anytime that you're actually going to print that piece of paper, you get to charge for that piece of paper. Again, we go back to the policy
Right.
that they shouldn't be doing that piece of paper, that they should just be able to download it for you.
Okay.
Yeah.
And then just one more thing, because I had asked for some attachments specifically, now it seems that they're uploading attachments to like the cloud, whatever the cloud is, which I still don't understand it entirely, but password protected. So to bypass that in the IPRA, they've just sort of like started sending stuff to the cloud on these other or not servers, but like other, like avenues instead of attaching it to the actual email. So how do we get around that in order to get that attachment?
Your broad statement there would make that a violation of the IPRA. Anything that's easily accessible to the public body, not to the public, but to the public body, if they have the password to do it, then it's public record and should be passed on to you. So that, like I said, your broad statement would be a violation of the IPRA. If it's easily accessible to the public body, they should be able to pass it on to you. This comes up a lot of the times with deleted emails. I've seen people say, nope, it's deleted, you can't get to it. If they can just click a button and get to it, then they should relay it to you.
Okay, thank you.
Yes.
Did you just say that if they printed it out, that I mean, I can understand they can charge you for it, but that doesn't mean you have to pay for it, right?
No, not necessarily,
Okay.
no.
Okay.
No, but it gives them the ability to charge you for it.
Because I've got 4,000 pages sitting that I'm not paying for.
No, but it does give the public body, I mean, of course, it's just a pass-over. These are public entities, they do pay for paper, they do pay for the copy machines, things like that. That's what the legislature put it in when it gave them the ability to charge you for it.
Yes, but it seems like it's their default.
We're strongly encouraging.
They go out and print this stuff out on their own for no reason whatsoever because they have it electronically already.
We are strongly encouraging electronic inspection to the extent possible. I mean, we actually encourage, and Dylan will tell a lot of public bodies this, set up a laptop and let somebody come in and scan through the laptop.
Exactly.
I mean, the electronic record is so much more efficient.
Yes.
Just post it on their website and go search it ourselves.
Yeah, there's that
Can you
too.
specifically request it just be electronic and not paper?
Yes.
I mean.
Yes,
and
whatever
comply with that,
you
or-
can. You can say whatever you have in an electronic format, please provide for me in an electronic format.
That include Excel, databases?
Databases are a little bit different because there's no requirement within the law to actually provide you a database, because once you can manipulate it, change it, anything like that. It may affect the public business realm. There's that provision in there. So databases are a little bit different, but any electronic documents, yes.
I understand that if I wanted a copy of a searchable database, I'm not asking to be able to change the the information that the agency would have.
So let me give you an example, is that an agency has a database that maintains the list of all of its customers, all of their phone numbers, all of their social security numbers, all of their addresses.
Redacted.
Yes. To give you just access to the database is too much. To create a record for you that would cut out their social security numbers is not required by the law. So that's where databases fall into that manipulable information. So that one's a little harder.
And if I just may say, so in our compliance guide, that's section 14.2.9A, and I encourage you to just look at what the guide.
This is where it allows them to do a partial printout rather than giving you an electronic copy of the database.
What if you could encourage them on your road shows to do more, create more databases that would get them would have to, they would have to redact.
It's a fact, yeah. We actually talk about that, and this issue has come up. We have actually stated that, is that when creating a public record, create one that you would be able to share. Don't put information in there that you would not be able to. Even when you're asking for forms or complaint forms or anything like that, either advise the public that this is going to be a public record, or don't ask for information that you wouldn't want to share. Yes, sir.
Another OMA question. As far as reasonable accommodations for recording, for instance, the Albuquerque City Council chambers have been regrouped, changed, and all of the public officials are now behind a little stem wall where the people like myself with a camera are locked out. And I can't get proper angles on those public officials to get their reactions to what's going on. Is that reasonable?
That has not been interpreted by the courts. That's all we have, is that one line in the OMA that says reasonable accommodation shall be made for audio and visual recording. The courts haven't gone any further to determine what's reasonable or how close you get to, or if you get to mic them, anything like that. So reasonableness at this point has not been interpreted.
Well, the other issue there is they've now corralled us into a, what is it, 10 by 3 space. And when we have all of the news crews there, it's impossible. It's absolutely impossible.
Yeah, the act is silent on that. Of course, the Attorney General's office would say give the most reasonable opportunity possible. I mean, what you're doing is providing information to the public. The AG's office would say go whatever steps possible so that we get the most information out to the public. But no requirement within the law other than reasonable.
So if we request records in electronic format, are they required to produce them in an electronic format, or they can decide that they want to do it in a paper format? Or is it a requirement at that point?
That part is kind of a fine line, because if they, and I've heard this a lot from public bodies, I'm sure Jillian gets this a lot. Yes, if they have them in an electronic format, they'll just they should and just email them over to you. Not an affirmative requirement within the law other than to respond to you in the same way. However, we hear from public bodies all the time is that they need to print out the record or provide it in a hard format in the event to redact. That's the one that we get, and we really can't fight that, because the law does allow for confidentiality or does allow for the exceptions. So if they're printing out to redact and they feel that that's a better way for inspection, or I mean, hypothetically, like the example I gave, if they don't have a laptop or a spare computer that you can come in and look at them electronically to inspect, then for that reason they can say that they could print it out. So it's not an affirmative duty within the Act, it's a policy decision we strongly encourage public bodies to make, but not affirmative duty for them.
Back to 14.2.9, when it said that exempt information shall be removed, etc., is that something they could charge for as part of personnel time, or are they not charging for that because it's part of determining if the record is subject to disclosure?
That would generally be subject to disclosure, so that's generally something that they shouldn't be charging for. It really depends, because I have seen public bodies where they have thousands of documents, and it does take an employee hours to do the redactions. So that one is kind of a fine line. I mean, there's no broad interpretation from the courts on that, and it would be a policy decision within the entity. But for the most part, we would say that you shouldn't be charging for that.
If you get a response and there are redactions, and there's no qualifications in their response saying, we have redacted, I mean, literally nothing about any redactions whatsoever. You know, we have redacted this under this exemption, that exemption. Is that kosher?
According to the law, that could be deemed a denial. They should give you the basis for any redactions.
Thank you.
Any other questions? Thank you so much for your time today. Again, we really appreciate you coming out and this sharing of information. The Attorney General that is completely open to anything that we can do to make information sharing easier for you all and transparency greater for the public bodies. So to whatever extent that we can do that, the Open Government Division has attorneys that will always be there to answer any calls. We have on-call attorneys that can just answer calls if you call in to the 6070 line. We provided these guides, and we're actually revising the guides. We hope to come out with new ones again this summer that give more information. I'm sure many of you have read them and we have the same examples, so kind of want to do some new examples that have come up. My card is over here. If anybody needs to contact me directly, I'm always happy to speak to anyone about these laws. Thank you for your time today.
Now let's